Everybody, it's just 10:01 on my iPad in front of me, so we'll start today's Countryside Rights of Way panel meeting. It's a short agenda, but as important as any other agenda, so we'll press on from here. Have we any apologies, please?
We have apologies, Chair, from Mrs Waring, Mr Abrahams and Mr Hudson. Sorry, my note's walking around. Sorry, Chair. Mr Hudson, thank you.
Thank you. Has everyone had a chance to look at the minutes of the meeting held on the 14th of July? Moved and seconded by Councillor Pritchard. Okay, we've all in favour, agree with that. Thank you. And we'll now move on to item number 4, which is the proposed addition to the scheme of delegation for the handling of Section 53 applications. I understand that Julie's going to update us on this one. Thank you.
Thank you, Chair. You'll recall that at the last meeting, or sorry, the one before last, you authorised a series of delegations to the Director for Corporate Services to be able to speed up the processes, really, for processing applications for Section 53s. Those delegations related to the determination of applications, as in whether or not a footpath exists. Attention is now turning to the actual making of the orders, and where determinations have been positive. With the making of the orders, there's a backlog of orders waiting, and importantly, within that backlog, if they're taken in time order, in receipt and confirmation order, determination order, there is a potential for some key orders to be waiting for quite a length of time. Primarily, those are the type of orders that relate to major projects, and the example we've put in the report is such as HS2, where they need to be brought forward. But also there's a situation where, for some cases, before they get to members, and then when they've been to members even, there can be a long lead-in with a lot of legal advice and a lot of legal background work and expertise involved. And the concern is that if those actual applications, once they're waiting to be made into orders, sit for a long time, that expertise is lost, the knowledge is potentially at risk of being lost, and therefore the council would be back to square one in terms of what it would have to fund and the research it would have to do. So those types of applications, particularly where they've been subject to court proceedings, are the other category of orders that the Director is asking, if you're granting delegated powers, to prioritise on the list of orders requiring to be made. This is a new delegation again, Chairman. It's a new full delegation, so it needs to go through to Audit Committee and then on to full Council for ratification if this panel support the proposal. Thank you, Chair.
Okay, this is quite an important delegation, particularly in the light of factors such as HS2. We do need to do everything we can to expedite the process. It is quite a long-winded process anyway, so if we can take one or two of the barriers out that keep that going, with, of course, member approval and member meetings where needed, but once we've had those meetings and made our decisions, we do need to get on with the job, basically. So I as chair agree with this, but we've got do you want to say something, David?
Chairman, I think that we've lived with this problem for so long that to look at some sort of solution to reducing the list, I think is quite vital. So I support the proposal with perhaps two qualifications. One is that we are very strict on them being non-contested applications. When we look back through the list of the 200 odd that we've currently got on our list, some of those have got objections, has been suggested, that are probably 30 or 40 years old, and the people who made the objections or supported are very probably no longer with us. So there is a need for us to dramatically reduce that list. So I support non-contested applications, providing we check that there is no new objections to something that didn't exist before. So I'm content with that. The only thing that I felt, which I've discussed with the officers, is that the applications, in the same way that we do from a planning point of view, although we have had officers delegated powers in planning, the planning committee receives a report on applications that have been passed under officers' delegation. And I think it's important that this committee sees what has been passed under delegated powers, and also that that's recorded formally within the council's papers, and that people can see from our reports that those applications have been dealt with under officers' delegated powers. With those sort of qualifications, I'm very content with what we're looking at. Thank you, Chairman.
From what Julie said, I took it a different way. I took it that the delegation is making the orders after we've decided at this committee, not before, as David is saying. So once we've made a decision at this committee, it then how the it goes on to the local plan, really, whatever it is. That's what the delegation is. So they've got the power then to speed things up. So if it's, I don't understand the path we deal with today, which is important to a lot of people, but some of the HS2 is greater importance to a large amount of people. That's the way I saw it. Not prior to coming here, it's after it's been to us. That's the way I see it, I'm sorry. Is that right, Julie?
That's correct, Chair. The decision that there is a footpath application, a valid footpath application, is the one that you've made either as a panel where there's been objections or under delegated powers, which is basically where we better define those delegated powers through the last batch of delegations that you authorised. This is the order being made and prioritising the list of the orders to be made that are waiting for your decisions to be actioned, so to speak. And the idea is to prioritise those that are major projects or those that would be extremely expensive or resource consuming if the council was in a position where it was, I don't know, say a 10-year gap between you making your decision, you've decided that an order will be made, and then it actually taking place. So, and it's the loss of that expertise, which is one of the key things, as well as where you, as you were saying, for such as HS2 project, the effect on the greater number.
I think we are pretty much on the same board here. What David said about a report on the delegations, I think it's important, but this is as you say, the next stage after the decisions. Can we have a vote on it? I think, is it a vote or a note on this?
I need you to vote to support the proposal,
Right,
Chair,
so
and then it refers on to audits with your recommendation that the delegation be made.
So on that basis, could we vote for or against this? I'm for it. Yes, unanimous. Thank you very much for that. And we'll move on, please, to item 5, which is the S53 application to add a footpath from Hollyhurst Lane to Blythe Bridge Bank, Kingston. And I think Hannah's taking this.
Yes, thank you, Mr. Chairman, members of the panel. So yes, this is an application for the addition of a public footpath from Hollyhurst Lane to Blythe Bridge Bank in the parish of Kingston. The application was submitted based on historical evidence, and this included a tracing of a railway deposited plan dated 1845 and a tracing of a Kingston tithe map dated 1838. So if I turn straight to the evidence, so the tracing of the railway deposited plan appears to show a route which does appear to follow a similar line to the alleged route. The route is marked with the annotation Foot Road and is numbered 43A. The information provided by the applicant is that the route was owned by a Reverend Edgerton Arden Baggett, and the route was recorded as a public foot road. So therefore, there is some evidence from this documentation that does support the route's physical existence, and it would also appear to support the route status as a public footpath. However, railway depositor plans should not be considered to be conclusive evidence, but looked at and evaluated alongside other historical evidence. When looking at the Kingston tithe map, so the tracing of the tithe map that was provided by the applicant did appear to show a route along the same line as the alleged route. Officers reviewed the Kingston tithe map that was dated 1838 online via the County Records Office digitised records. And on checking that it was the same map as described on the tracing, we could not actually find any route depicted on the tithe map along the same line as the alleged route. Therefore, the evidence from the tithe map from the Records Office does not support the physical existence of the route, and therefore it did not ultimately provide any supporting evidence in the case. On submission of the application, we did receive some feedback. The Ramblers Association responded advising that they had no supporting evidence in relation to the application. The Pecan Northern Footpath Society also advised that they had no evidence in relation to the application. No landowners provided comment on submission of the application. So when we consider the relevant legal tests, the application is made under section 53, 3C1. Therefore, the relevant legal tests are whether the evidence shows the route exists based on the balance of probabilities, or whether it can be reasonably alleged that the route subsists. So to summarise, the tithe map does not actually provide any evidence regarding the existence or the status of the route. The Railway Depositor Plan does provide some evidence of the existence of the route with the status of a public footpath, but without any further documentation to support this, it is officers' opinion that the evidence is insufficient to support the existence of a public footpath along the line of the alleged route. Therefore, to conclude, when the documentation is considered, it cannot be said that either on the balance of probabilities or that it can be reasonably alleged that the alleged route exists as a public footpath. Therefore, officers' recommendation is to reject the application and for no order to be made to add the alleged route to the definitive map. I'm happy to answer any questions.
Thank you very much for that. Paul.
Hannah, thank you for the report. Nice and simple, straight to the point, really. No evidence from anybody, really. No objections from the county councillor. Ramblers Association don't agree. The Pete Walkers don't agree. There's evidence there. Balance of probabilities and reasonably say it doesn't subsist. It doesn't exist, really. The tithe map, whatever it is. So I will go with officer recommendation and propose that we don't add it to the definitive map.
Councillor Richard.
Thank you. Paul stolen most of my thunder, so just second his motion.
He does like stealing thunder. So we've got a proposer and a seconder that we follow the officer's advice on this and don't take it forwards to the definitive map. All those in favour? I think that's unanimous. Thank you very much. And there is no other business apart from me saying thank you to the officers, thank you to the members, and please enjoy one really sunny day. Thank you.